Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular episode, I'd like to talk about a form of relief in removal proceedings that actually was not current law until prior to 1996 and was repealed after that. And yet today, people can still apply for 212C relief if the facts are appropriate. Now, it just goes to show you that if Congress makes a law and the president signs it, and it turns out to be unfair, unconstitutional, improperly applicable to current law and so forth, that lawyers all over the nation will fight, will bring lawsuits. It'll go up through the circuit courts, and eventually it'll get to the U.S. Supreme Court, who will make a decision on the matter. And that's what happened here. 212C relief, for all intents purposes, is basically a get out of jail free card. Okay, it's when you already had your green card for a certain period of time, you committed a crime, you're put into removal proceedings, and at the time it was deportation proceedings, and they try to deport you because of it, and you essentially show through trial essentially why they shouldn't deport you. Okay, you say you show how sorry you are for the crime that was committed, and it's like a scale. Okay, the good stuff's on one side, the bad stuff's on the other, and you put the trial in front of the judge, and the judge decides. Now, I realize that I just greatly oversimplified how you do a 212C hearing, but that's the basics. Okay. And when IRA came out in 1996, they repealed 212C. They replaced it with what's called cancellation of removal. They made it more difficult to win. If you had a choice between a 212C hearing or cancellation, you'd pick a 212C in a second because the burden of proof isn't as much and the probability of winning is higher. So it turns out that they couldn't just repeal 212C for people who were later put in removal proceedings but committed crimes before the repeal of 212C. So I do have other videos on 212C, but there's one particular aspect I'd like to speak about, which is very important in a 212C hearing. Now, for many years after, Sincere came out, which basically said that 212C can still be applied for, many years after, what happened is, someone would commit a crime prior to 96. It would fall under all of the provisions of 212C, but then they would commit a crime after 96. Okay, and there was essentially all the rulings, and all the courts said, well, look, you qualified for 212C before you committed the second crime after 96, but now that second crime kicks you out of 212C, and now you have to apply for cancellation, of which case most of them wouldn't apply because the crime, prior to 96 may be designated an aggravated felon in today's day and age, and because of that, they wouldn't have been able to apply. So there was actually a case, different cases that came out about 2014, okay, about 5 years ago, which essentially said if you qualified for 212C, then even if you committed crimes after 96, those crimes are all going to be folded into the 212C hearing. And because of that, and because of all the fighting that all the lawyers did over the nation, now, people aren't in limbo as far as 212C goes, aren't put to a test where they know they can't win, and get a fair shot at a 212C hearing. So, if you committed different crimes in a span of a bunch of years and you have no idea if you qualify or don't, give me a call. Give my office a call. We'll set you up on a consultation and we'll let you know. It would be a shame to give up, sign a deportation order, and stay who knows how many years in your home country, when you might qualify for a 212C in order to keep your green card. Okay, so if you like the video, click like, subscribe, and more on the coming videos. Thank you.